Welcome back. So the acquittal of rape accused the televangelist Omotoso has sparked concern and calls for accountability. The Gqeberha High Court cleared Omotoso and his co-accused of all 32 charges, including human trafficking. The Justice Minister, Mmamoloko Kubayi, has now demanded a report from the National Director of Public Prosecutions, Shamila Batohi, to clarify the circumstances. Let's now bring in the Portfolio Committee on Justice for their reaction to this matter. Oscar Mathafa is now joining us this morning. A very good morning to you. Thank you so much for making time for us. The committee had issued a statement immediately after the judgment was handed down. The minister has now also issued a statement, but the minister goes as far as saying that she wants a full report from the NDPP around what happened. I've decided to invoke Section 33, subsection A of the NPA Act in relation to the Omotoso and other cases. The judge was scathing in her judgment, criticizing the poor quality of the state's cross-examination. As the committee, what do you make of the step that has been taken by the minister?
Good morning, Aldrin, and all the viewers at home. Thank you for having me this morning. Aldrin, firstly, our statement was triggered by the displeasure that the Portfolio Committee wished to communicate on the acquittal of the accused. And as such, we are in full support of the Minister's invocation of Section 33. She is the final authority on prosecution, and as such, the NPA Act gives her powers to request a report on any case. In this case, we believe that it justifies her invoking that particular section. Because, Aldrin, you will note that this is not the first case where the poor performance of prosecutors has been raised. There is a case of the Utugela water case where an investigator complained that one of the prosecutors was either grossly dishonest or incompetent. And in the Nulani investment case, the court lamented the fact that evidence was not forthcoming from the prosecutions. But now, Aldrin, this one is a different case because we view it as a high-profile case, simply because it touches on what the president terms the second pandemic of gender-based violence. And the case included rape, sexual assault, and human trafficking. Now, what perturbs the committee, Aldrin, is not only the poor cross-examination of the accused by the prosecution. The complete handling of the case was appalling. It has been reported, and the judge mentions this in her judgment. There have been instances where prosecutors have had to be replaced, but the replacement took way too long. And that also impedes on the victim's rights, because the mandate of the prosecution's authority, besides taking up gender-based violent crimes on behalf of the state, it's to ensure that victims are protected. And when you look at the feelings that were displayed in public view by a brave lady, Ms. Zondi, you can see that this case flew in the face of all the efforts that we as government and society are putting in place to ensure that gender-based violence is eradicated once and for all. If you allow, Aldrin, I will just share a few things that in Parliament we have put in place to try and deal with the issue of gender-based violence. We have brought amendments to the Criminal Law, Sexual Offences and Related Matters Act with the view of expanding the scope of sexual offences and to strengthen protection for victims. And we believe that here the NPA dropped the ball by not protecting the victim. So when the minister calls for a full report, we hope that in that report, the NPA will also elucidate on how they supported the victims, pre-trial, during the trial, and now with this particular acquittal. Because it is also mentioned by the judge, and in various reports it appears, Aldrin, that the cross-examination of the accused only lasted for less than a morning. This is an 8-year trial, and the cross-examination only lasts for less than a morning. And maybe it's important, Aldrin, to remind the world and South Africans, and particularly the victims of this accused, that the case was not lost purely because the accused was truthful, or was it lost because the victims were not entirely truthful. It was lost on the basis that the NPA performed poorly, and the judge characterizes the cross-examination as lacking intent to extract the truth. Now, it cannot be skating than that, Aldrin, where there is no intention to extract the truth. Because with cross-examination, as a state, you have an opportunity to weaken the case of the defense by trying to identify inconsistencies in the testimony of the accused, by extracting admissions where the accused can be cross-examined to a point where they admit to certain evidence that has been adduced by the state. But if you're going to take less than a morning on such a high-profile case, we believe that thorough consideration of the severity of this matter was not taken into account. And this undermines the credibility of the institution and the entire justice system and the upholding of the rule of law.
Yeah. The committee has also asked for answers around what happened here. For what intention would that be to get the answers around what has transpired here? Because as it stands, Timothy Omotoso and his two co-accused remain acquitted.
Aldrin, last year around October 2024, we hosted the NPA. And in the annual report, they would have listed certain areas of concern, and we picked up challenges that we believe that must be addressed as soon as possible. One of them was the low conviction of sexual offenses and other internal challenges. And there were commitments that were made in terms of how the prosecution will be strengthened. So because the minister, as per the provisions of the NPA Act, is the final authority of prosecutions, she has the right to call for answers. And we believe that when these answers come forth, we will then be able to compare these responses to the commitment that were made by the NPA in the engagement that we had with them in the committee. As a committee, we are meant to support the entities falling under the Justice Ministry and also hold the executive accountable. But it will be difficult, Aldrin, to assist and capacitate these institutions if they are unable to live up to the commitment that they made. And our primary focus will be to see what measures have been put in place, one, to strengthen the capacity of the prosecutors. Secondly, to look at how they can improve their low conviction rate of sexual offenses. It would have emerged, Aldrin, in the same report that for financial year 2023-2024, there was a 2% increase on convictions of sexual offenses. However, when you look at the previous performance, it was a drop from 74.8% the previous financial year to 70%. So whilst we welcome the 2% increase, we cannot ignore the fact that it is coming from a negative base where there was a reduction in the previous conviction. So the answers will assist us to be able to oversight, firstly, the department, but secondly, the competency of the NPA in fulfilling the commitments that they would have made to the committee.
Yeah. Advocate Ismat Serfontein was one of the prosecutors. He was part of the prosecuting team in the trial. But later in 2020, we understand that he stepped down in March 2020, according to the Herald report, because Cheryl Zondi had written to the NPA claiming that Serfontein was, as the Sowetan reports, quote, almost racist and treated witnesses poorly. But the point that was stressed in the trial as well, in the judgment, was that it's not ideal for a victim to have a say on who a prosecutor is, prosecuting their matter. And if you take a consideration, for instance, Serfontein is the same advocate that led the state's case against Moses Gresha, who has been convicted for 15 years for allegedly raping a businesswoman, Kawa, back in 2010.
I understand the perception, Aldrin. However, as I initially indicated, in the mandate of the NPA, core to the victim's role in any trial is their protection that must come from prosecution. And if the victim that is intended to be protected does not feel protected or does not feel supported enough, we believe that it's their duty to raise these concerns. And the NPA will make final determination in terms of the veracity of the submissions that were made. So if at that time the NPA would have decided that there's merit in what the victim is raising, I believe that they would have passed constitutional muster to take the action that they would have taken to replace the prosecutor. Because at the heart of the victim's role is their protection by the NPA.
Yeah, but don't you think that that could have affected the trial itself as well, and possibly even a conviction, considering once again that in the Moses Qesha case, he was able to secure that conviction?
I would not know, Aldrin, but there has been rumors around Advocate Serfontein and the senior state advocate in the Eastern Cape. I think it's Miss Advocate Kweba, not Miss, it's a gentleman. There were also allegations of misconduct from the two, where amongst them there was a discussion that certain evidence, especially communication evidence, should not be included because they may tamper with the state's case. Now, if you put all these particular instances and these allegations, it will really be difficult to directly point to the impact that his removal would have had in the successful prosecution of the case.